Friends, I would like to introduce my team. We are on the side of prosecution in the instant case of the state versus Armakan and Dawa. I'm the first mooter Hasnad Hamid and I will be argumenting on the first two questions. My co-mooter Ms. Myra Sobat will be argumenting on the remaining three questions. And with us is our legal researcher Ms. Isma Riaz. She will be providing authorities to the honorable judges. Before I start, may I? Yes. My name is Hasnad Hamid. Before I start, may I ask if the Honorable Court is aware of the facts of the case? Sure. I would proceed to the first question, that is about the question of jurisdiction, whether the state of Juristan has the jurisdiction. Indeed, Your Honor, state of Juristan has the jurisdiction. Your Honor, according to the United Nations Convention of Law of Seas, the state of Juristan has an exclusive economic zone which is extended up to 360 nautical. Incident took place somewhere around 250 nautical. To fierce my arguments, I would like to mention territorial principle of international law, which says that whenever any incident takes place within the territory of any state, the same state has the right to adjudicate the case regardless of the nationality of the accused. In order to support my arguments, I would like to present a case law which is Campania Naviera Viscangado versus Christina SS 1938. In that case, Your Honor, the ship was of private company, however, it was used by the Spanish government for the purpose of trading. Hence, it was held that the ship is in the jurisdiction of Spanish government. And the same principle is applied in the instant case as vessel was in the territory of Juristan. Hence, the Juristan has the jurisdiction. The second principle which I would like to mention here is universal principle of jurisdiction, which says that this legal principle permits or allows the states to claim criminal jurisdiction over the offenses that are committed within the regardless of the territory and regardless of the nationality of the accused and any relation to the prosecuting entity. At last, I would like to mention Section 4 of Juristan Penal Code. Are you with me, judges? May I read, Your Honor? Sure, thank you. It says that any citizen of Juristan or any person in the service of Juristan in any place without and beyond Juristan. The word any person in the service of Juristan clearly implies that it attracts Mr. Armagan and Dawa and the Razain Kazalbash. Hence, keeping in view the territorial principle of international law, universal principle of international law, and Section 4 of the state of Juristan has the jurisdiction to adjudicate the case. If the honorable judges have no question, I would like to proceed to question number 2.
What are the essential ingredients of Section 4 of JPC?
Your Honor, number 1, it can be citizen of Pakistan. The second is the person in the service of Juristan. In the service of Juristan. It means he must not be the national of Juristan.
Okay, so he was in the service.
Yes, indeed, Your Honor.
His services was not, the contract was expired.
Your Honor, it is not. Your Honor, it is not clear because when the shark hit the ship, it destroyed the systems of so it cannot be clearly said.
The chronological order of the dates were given in the effects.
Indeed, Your Honor, but as I said, the systems were destroyed. It is not exact, Your Honor.
It is a common sense to assess that is the day and night and how many days it passed.
Yes, Your Honor, but it is still probably. It is not confirmed. So I would like to proceed to question number 2, which is whether killing of the Razain Kazalbash was murder considering the circumstances of the case. Your Honor, indeed, it is Qatl Amad because according to the definition of Qatl Amad under Section 300 of Juristan Penal Code, to be very brief, it says that there must be intention and knowledge of act which cause grievous hurt which lead to the death. Now, I would like to request honorable judges to please refer to para 9 and line 5 of the given facts of the case. We can clearly see that the Armagan and Dawa is offering prayer, whereas Firoza Bill is grasping the legs. Meanwhile, Armagan and Dawa used his penknife to cut the jugular vein, which caused his death. Hence, in order to intensify my arguments, I would say the accused can come within the mischief of this section only if death is the direct result of injury. And hence, the accused must have felonious intention. To support this notion, I would like to rely on the landmark judgment, which is JLD 1976 SC 37. Your Honor, please refer to para A. May I read?
Yes.
Your Honor, it says felonious intention and causing injury resulting in death. Felonious intention of accused, hence proved. The second thing which I would like to mention here is confession, Your Honor. Right after they were rescued by the Zabada Coastal Guard, they voluntarily confessed all the happenings at the ship. Hence, it attracts the Article 37 and Article 41 of Kanuni Shahadat Order Juris.
of the confession before the coastal guard.
Sure, Your Honor. If you allow me, I would like to read the. Your Honor, it says if the confession is made after the removal of three things. Number one, there must be no threat. Number two, there must be no inducement. Number three, there must be no promise. Then your confession become relevant. And from the facts of the case, it is clear the confession was voluntarily and all the three ingredients were absent in the instant case. So hence,
There is a separate principle in Kanuni Shahadat order that the confession done before the police is not admissible in court.
yes, Your Honor. Yes, you are referring to extrajudicial confessions. Yes, Your Honor. But it is said that after corroboration of extrajudicial confession with facts and evidences, it becomes relevant, and we can present coastal guards as a witness in the court as well. Hence, Your Honor, keeping in view the Section 300 of Juristan Penal Code, Article 37 and 41 of Kanuni Shahadat Order, it has been proved beyond reasonable doubt that Armagan Randawa admitted and confessed about the incident of murder of Hussain Qazalbash. If the court has no more questions, I would like to call my co-accused or co-mooter to please proceed. The other, may I, Your Honor?
No.
Yes.
The question is there is no punishment in GP C. Then in which provision you are in front of us? Which provision you want us to punish?
Your Honor, as I referred, as I
Is
mentioned.
there any punishment of cannibalism in GPC?
Oh, sure, Your Honor. Regarding cannibalism, there are some customs, Your Honor. And for cannibalism, my co-mooter will be better guide you. And if you ask me about specific law under which they must be punished, it's under Section 300, Your Honor, of Juristan Penal Code.
The cannibalism is not a part of Section 300.
Of course, Your Honor. And as proceed, Your Honor.
Yes.
Thank you. Now I would like my co-mooter to please come. Thank you, Your Honor.
Good morning, Your Honor. This is Mahira Sobat, second mooter in the instant case of Armagan Randawa versus State. State versus Armagan Randawa. So I believe that my co-mooter, Mr. Hasnat Hamid, has argumented beyond any reasonable doubt and to the satisfaction of court. With the prior permission of this honorable court, may I proceed towards the third issue of the instant case? So, Your Honor, the third question in the instant case is whether only Armagan Randhawa is liable for killing Dilrozin Qazalbash or not. Your Honor, from the facts of the case, it is clear that not only but Ferozabil and other crew members are also liable for killing Dilrozin Qazalbash. So, hence we can say that Armagan Randhawa can be called as principal accused in the instant case, whether as the rest of the crew members can be called as the co-accused in the instant case who abetted the offense of murder. Abatement is defined under Section 107 of Juristan Penal Code. In the instant case, Ferozabil is considered as the abater who aided and instigated Mr. Armagan Randhawa. Furthermore, to strengthen my instant notion, the reliance is put upon a judgment that is JLD 1961 Lahore 212. I would like to seek the attention of this honorable court to the para 1, that is the highlighted portion of the instant judgment, that is the page 1. May I read, honorable
Yes.
judges? So, the general rule is that not charged, but there are two exceptions to this general rule which are provided for in the section 257 and 238 of the Criminal Procedure Code. This section enables the court to convict person of an offence which from the evidence he is proved to have committed and for which he might have been charged. Therefore, if a person might have been charged for an abatement of an offence under the provisions of section 236 of Criminal Procedure Code, then he would be convicted for the abatement although he was not charged with it. Your Honor, to make the instant judgment relevant with the facts of the case, so where a person is not charged with an offence, but he has abated the offence and the offence is it has not been mentioned in the charges. Therefore, I have referred this court to the JLD 1961 Lahore 212. It clearly says that if a person is not charged with an offence, still he can be convicted in where the offence is committed in reference to the abatement. Therefore, it is relevant in the instant case, Your Honor, if not separately charged.
Counsel, do you not think that abatement is not a relevant section and it basically does not attract the argument, the charges?
Your Honor, it attracts the charges because
what I have perceived that there was no intention of instigation. It was just a suggestion.
If the fact says that Fairozabil signaled Mr. Armagan Randhawa, this signaling is referring and signifying that Fairozabil instigated Mr. Armagan Randhawa and Fairozabil grasped the legs of Armagan Randhawa while Armagan Randhawa
There was an intentional aid, but there was no instigation. Considering that all the essential ingredients of abatement are not fulfilled, so I believe that the charges of abatement is or are not attracted.
Your Honor, as I've already defined that Fairozabil instigated Armagan Randhawa to kill Dildozen Kazalbash when
How do you prove the instigation?
signaling, Your Honor. Signaling is strengthening the instant notion that Fairozabil instigated Armagan Randhawa.
Signaling and instigation is also different.
Still, if the court is
If I am indicating something, if I am suggesting something, that would not mean that I am tempting you or provoking you.
still if the Honorable Court is not satisfied with my instant notion, so I'm really sorry for the inconvenience. May I proceed further?
And we come to the parameter level of the state. That's
Yes, Your Honor.
and you read the parameter level of
There is no para number 11, Your Honor,
you have
in the facts.
anybody have the facts
There is.
of the cases.
It has only 10 paras.
For the next 4 days, after you fed on the body, boy's body and drank his blood while eating Elga Bill asked, this meat is very nutritious, delicious, who for this fish? It means there is no abatement. He doesn't know anything about the killing of that.
Your Honor, may I beg your pardon, please?
If somebody is not even knowing the crime has been there, how can one be the part of abatement?
Your Honor, you are asking about the intention of Aruza Gill.
Intention and be the part of that all situation.
Aruza Gill is the part of the instant happening, Your Honor.
How can we be abated by the Almara?
So, Your Honor, I would, in order to strengthen the instant notion, I would rely upon a judgment that is JLG 1996 SC 746. Your Honor, here the highlighted portion of the instant judgment signifies that intention is a state of mind which is not susceptible of direct proof and can only be inferred from the attendant circumstances of the crime. Existence of common intention, which usually consists of motive, preconcept and pre-arrangement, cannot always be proved by direct evidence. Held common intention has to be gathered from the facts disclosed in the evidence.
That is what I am asking you. If Arosa will He doesn't know about that flesh. How can you bring him into the intention?
I would refer you to the para 7 of the facts of the case. And line 4. It mentions that the crew openly discussed the possibility of cannibalization. This openly word signifies that the common intention of Aruza Gill existed at the time when the discussion of cannibalization was made, and the same was not objected by Aruza Gill. Hence, the intention can be inferred from from these facts, according to the judgment which I have presented for this honorable court.
For the council, there are two things. One, that discussing and suggesting each other about something, yes, it gives a sense of that a guilty state of mind, yes.
Yes, Your Honor.
And later, if you are implementing or executing it, it leads to the attempting of murder or commission of murder. That means it's a conduct crime. Do you think that Aruza Gill, who was the part of discussion, but she was not a part of that conduct crime?
So she was
Mind, but there was no conduct crime.
I would prefer another judgment before this honorable court about the existence of the intention of the Aruza Gill. That is 2020 PCR LJ Note 94. So, Your Honor, I would like to have your attention on the page 5, last line of the instant judgment produced before you. May I read, Your Honor?
Yes, ma'am.
Your Honor, it is mentioned that if several persons would unite with common purpose to do any criminal offense, all those who assist in the completion of their object would be equally guilty. Foundation of constructive liability was the common intention in meeting accused to do the criminal act, and doing of such act in furtherance of common intention to commit the offense. In order to constitute an offense under section 3(4) of Juris Penal Code, it was not required that a person should necessarily perform any act with his own hands. If several persons had the common intention of doing a particular criminal act, and in furtherance of their common intention, all of them joined together, aided or abetted each other in the commission of the act, then one out of them could not actually with his own hand do the act, but he helped by his presence. I would like to have the attention of this honorable court on the instant point that one helped by his presence. This is the relevant about the common intention of Aruza Gill in the instant case, as it is these are not my words, but these are the words of the honorable judges, which is already given their decision under the citation 2020 PCR LJ Note 94. May I proceed further? So there is another issue, that whether cannibalization is lawful under theory of necessity or not. Your Honor, cannibalization is not permissible and not justified even in the situation of necessity. Cannibalization is an act of consuming other human body's flesh. It is considered as murder because where culpable homicide amounts to murder, then a cannibal must also be charged with assist this honorable court with the case law of Regina versus Dudley and Stephen. Your Honor, I seek your attention on the para 1, that is the highlighted portion of the instant judgment. May I read, Your Honor?
Yes, ma'am.
A man who, in order to escape death from hunger, kills another for the purpose of eating his flesh is guilty of murder. Your Honor, these points should be noted by this honorable court. Although at the time of that,
your time, sir.
Your Honor, I request you to complete my this instance. Furthermore, I will proceed towards the prayer clause.
Your time, please.
Thank you, Your Honor. So, is guilty of murder. This must be noticed by this honorable court. Although at the time of the act, he is in such circumstances that he believes and has reasonable ground for believing from the instant case law that if the sole survival of a person depends on killing someone, still he cannot kill any other person. In the instant judgment, the judges made it clear that they did not consider necessity as a possible justification for murder regardless of the circumstances of the case, even if this was the sole way to ensure the survival of the others. Later on, it has been set up as a precedent that cannibalism is prohibited under the theory of necessity. So it has been clear. Furthermore, I will proceed towards the prayer clause with the permission of this honorable court. So, keeping in view the arguments advanced before this honorable court, I humbly and most respectfully pray to this court that the Armagan Randhawa should be punished under section 302 of Juristan Penal Code and with other hefty punishment for the sake of justice, equity, and fair play, which this honorable court might think fit. Thank you, Your Honor.
Good morning, Your Excellencies. May it please the court. My name is Salim Javed. I appear on behalf of the defendant, along with my co-counsel, Ms. Samira, and our legal researcher, Khalid Khan. I will be discussing the first two issues of the case, and my co-counsel will address the rest of the issues. And I will take 10 minutes of the court's time. Our first submission is that this honorable court has no jurisdiction to try for three reasons. Your Excellencies, I would like to move your attention towards the page number 9, the second paragraph. As per the Article 97 of UN clause, in the event of a collision or any other incident or of navigation concerning a ship on the high seas involving the penal or disciplinary responsibility of master of any other person in the service of the ship, no penal or disciplinary proceedings may be instituted against such person except before the judicial or administrative authorities, either of the flag state or of the state of which such person is a national. Your Excellencies, my first point is Mr. Armagan Randhawa and Dilrozin Kazalbash are both the nationals of the state of Nana. They are not the nationals of the state of Juristan. They were in a contract for 1 year, which was already expired before the offense was committed. My next point, the vessel used by Armagan Randhawa and the expert team was registered in the state of Babul, which is one of the states of Dilaram. Thus, the contract was expired and the vessel was given registration for 1 year, which was to facilitate the expert team. It directly means that the contract between the federal government and Zizo company was already expired. Your Excellencies, according to the section 4 of JPC, may I read it, Your Excellencies? Any person on any ship or aircraft registered in Juristan, wherever it may be. Juristan is only having the jurisdiction to adjudicate any case where the ship is registered within the authorities or within the boundaries of Juristan, not any other flag states or not any other states. Your Excellencies, in the second line of facts number 10, it is said that, it is quoted that offense was committed probably 250 nautical miles away from the human contact. The human contact never means that the yacht or the vessel was moving towards the state of Zawada, or it was not moving towards the Juristan. It could have been any other place. It was the human contact only.
You already said it is the word from that way. It means it's doubtful. It is not clear.
It's doubtful, indeed. Thus, the prosecution has claimed that they have the jurisdiction. But as per the doubts, we have no jurisdiction. This honorable court has no jurisdiction to try the case. As I've said earlier, the contract was expired. The contract was made for 1 year only.
Date is mentioned, the claim date specific.
To 11th to 13th of June,
It
proper.
is again probably. It Means it is not
As per the
confirmed
facts,
whether
ma'am.
the contract has been expired or not.
Indeed, Your Excellency. But as per the facts, the contract was expired on 1st June 2023, just because the contract was made for 1 year and it was started on 1st June 2022. And the offense was committed between the 11th and 13th of June. Wherefore, in the light of issues raised and the arguments advanced, it humbly prayed that this honorable court has no jurisdiction to try the case, and the matter shall be referred to the competent court of law. Your Excellency, may I move to the next submission?
Council, for the sake of this argument, let's say that the contract was expired, right? The members of the crew were not the nationals of Juris, right? But what do you say that the offense was committed within the local ambit of Juris? Since it is mentioned in the facts that the exclusive economic zone is about 200 nautical miles, and it's also extendable to 360 nautical miles. It means that it definitely comes within the ambit, within the jurisdiction of this course.
Indeed, Your Excellency, as per the facts, fact number 10, Your Excellency, I would like to read the next sentence of the fact number 10 for you. They were still standard probably 250 nautical miles away from the human contact. As I've said earlier, human contact never means that they were moving towards the port of Zawada. It could have been any other island or any other place of human, but it wasn't. It is not sure as per the facts that they were moving towards the port of Zawada. May I move further for argumentation? The next issue in this case is whether the killing of Dilroz in Qazalbash was murder considering the circumstances of the case or not. Your Excellency, the murder or the killing of Dilroz in Qazalbash is doubtful. As per the facts, he was in coma. He consumed the seawater. He was a man of expertise in marine geology, oceanology, and international law. Being a man of expertise, he had reason to believe. The reason to believe is defined in section 26 of JPC, which states a person is said to have reason to believe a thing if he has sufficient cause to believe a thing, but not otherwise. He had reason to believe that what would be the consequences of consuming the seawater. He was a man of expertise in oceanology. He would have known the consequences of drinking the seawater. As per the medical terminologies, the sodium inside our cells need to be balanced with the sodium and water outside our cells. The seawater contains 35 grams of salt, whereas the average requirement for the human body functioning is 9 grams of salt, which in ordinary sense means that Dilroz in Qazalbash was himself willful for his death, or he was nearly committing suicide.
So the proximity to death allows you to kill someone.
Your Excellency, it never allows somebody to kill anyone. But if a person is himself willing to die and the others are facing an extreme necessity, in such a situation,
Show his consent.
he has showed his consent once, but later on he denied that he has promised to marry her on the return.
So
But
you are indirectly admitting that he retracted his consent.
he initially retracted his consent, but later on he had reason to believe that consuming seawater would cause his death. Knowing the consequences, he drank the water, which in result was a kind of committing suicide. Your
You
Excellency,
are
please.
saying that he has the murder, there is no any murder has been happened. He has just, the death is natural death by consuming seawater. Can you?
No, Your Excellency, my point is that he was killed at the time when he was about to die.
About
Yes, Your Excellency.
you know, there in law there is no maybe probably about to. There should be a confirmed and constructive proof.
Your Excellency, as per the facts and the grounds, he was nearly to death. and they were required to live for some more 5 to 7 days or 4 to 5, 6 days, whereby he was not sure to live with her.
Then, what circumstances or in what provision one has been allowed to eat the other living being?
The consequentialism school of thought and the utilitarianism school of thought, they suggest that the ethical dilemmas should be decided on number-based logic. If Armagan Randhawa did not kill Dilroz and Kazalbash, it could have the consequences as the death of all the crew members in the ship.
If you go through the set, they have also caught a turtle. If they once can caught a turtle, they can do it again.
The turtle was by chance given to them, Your Excellency, but they were not sure though that they could have some more turtles to eat, and
It means they can caught fishes from the sea.
but
They have chances.
but
There is no law of necessity.
but it was not the force of hunger only. They required water or any liquor to survive, Your Excellency.
Move on.
What is the significance of this consequential school of thought law?
It has a lot of importance in the concepts of jurisprudence. We have been analyzing and interpreting the laws which are required, which are not given all the definitions in the statutes or any other laws.
Is there any provision or law or statute mentioning that maximum satisfaction of a person should be like the minimum?
There might be some relevant laws, Your Excellency, but the Council apologizes for being unaware of the fact at this time.
There is no law, how can we consider
The jurisprudential concepts, we interpret the law, the question of law, in such a situation where no statute has defined any concept like that. Then in such a situation, the consequentialism school of thought and the utilitarianism school of thought have a lot of importance to interpret that law. We have a case law which is related to the state of Queensland versus Eliza and Eno, 2001 QSC 174. Your Excellency, this is a case whereby two conjoined twins were separated by operation, and the Supreme Court of Queensland ordered that the separation must be carried out in an attempt to save the stronger one. I would like to refer you to the page number 3, Your Excellency. The result of surgery: chance of Elisa's dying 60 to 80%, chance of Bethany's dying 100%. In knowing ordered in the page number 1, Your Excellency, may I read it for you? I declare that an operation to separate the conjoined twins Eliza Grace Nolan, Bethany Rose Nolan may be lawfully carried out in an attempt to save the life of Eliza Grace Nolan. I order that Eliza Grace Nolan and Bethany Rose Nolan be permitted to undergo, and the applicant's servants and agents be permitted to perform surgery to affect the physical separation of the children. Knowing the consequences that one of them could have died, and he was obvious to die, the chances were 100% according to the doctors and the surgeons. The court ordered that the stronger one should be living for the rest of the life, but the weaker one.
But still there is a chances to live.
yes?
One still has chances to live.
But the principle has been said by the Supreme Court of Queensland that the weaker one could have been separated just to make the other one to live.
It is not related to this situation. When, as you said, last necessary, still she has the chance to live. Now, in your situation, you have killed a living being.
The conjoined twins were living at the time, Your Excellency, and the court ordered the stronger one had the chances from 60 to 80% of living, but after the surgical process, the weaker one was obvious to die. But still, they did the surgery and the court ordered them that they should carry out the surgery in attempt to save the stronger one, Your Excellency.
How would you compare a medical or a natural fault, a natural defect with a technical fault?
The point is, Your Excellency, that the weaker one, according to the directions and order of the Supreme Court of Queensland, that in certain situation whereby you have two options where both of them are definite to die, and on the other hand, you can save one of them, then you must save the stronger one, Your Excellency. If I'm of no further assistance, may I call me the next mooter? Thank you, Your Excellency.
Good morning, Your Honor. This is Samira Haidar on the behalf of defense. Your Honor, may I proceed with my argumentation? Whether only Armaghan Randhawa is liable for the killing of Dilrozin Qazarbash or not, Your Honor, it is humbly submitted before this honorable court that Armaghan and others are not habitual offenders. It means that they have no earlier or prior criminal records, Your Honor, and are neither habitual cannibals. Whatever they committed was purely, Your Honor, under the doctrine of necessity. They were in a situation which was extraordinary. It was not an ordinary situation. And whatever they did was under this doctrine, Your Honor, and they were left with no other options based on the aforementioned and following reasons, statute, precedents, and maxims and laws. Your Honor, furthermore, the necessity principle can be very well explained and can be very well defended by some Islamic principle laws, which states that necessity removes restriction. Your Honor, according to Islamic principles, when you are in certain circumstances which are extraordinary, and there are, Your Honor, chances of you losing your life, then certain things which are otherwise haram becomes permissible, Your Honor, under certain circumstances where situations are extraordinary and there no other alternative is before you. In the Quran, Almighty Allah says, Your Honor, O Muhammad, I find not that which has been inspired to me anything forbidden to be eaten by one who wishes to eat it, unless it be a dead animal, a blood poured forth by slaughtering or the like, or the flesh of swine, for that surely is impure or impious, meat of an animal which is slaughtered as a sacrifice for others than Allah. But whosoever is forced by necessity without willful disobedience, no transgressing due limits, certainly your Lord is forgiving and most merciful.
You mentioned not transgressing due limits. What is due limit?
Your Honor, due limit means when you are under for example, in this case, Your Honor, to the limit that is necessary for you to live and not die.
So it means that if the court adjudicates in your favor and set a precedent that in such